Hello everybody. Welcome in. Good to see you. Ooh, goodness gracious. Here we go. I'm working on it. Happy lunch hour. I do like to hop on sometimes over the lunch hour to catch some people that may not have been able to catch my evening live. Sometimes I go in the morning too. But today I thought we could do a little lunch and learn. Hello. Hi, Duchess. Hi, Nancy. Willie B. Hello. Welcome. Lenny. Hello. Good to see you all. Hello. Hi. Yes. Hello. Happy day to you too, Thomas. Oh, the nails. Well, I'm still doing my rainbows. So, although technically not rainbows, but lots of different colors. So it kind of looks like a rainbow. A rainbow of lava. Hi, Stacy. Hello. Hello, Lex. Hello, Ashley. Well, welcome in, everybody. Just got off of work. Oh, okay. Oh, thanks, Allison. Yeah, I love them. Doing so far so good. Yes, we're doing a lunch and a learn today. So there was an order that came out yesterday. Yesterday was kind of a weird day because there was a lot of stuff going on that prevented other stuff from making headlines, right? So we have here a preliminary injunction that's been granted in part and denied in part. This is a case regarding the Alien Enemies Act. So I thought it's a short decision, and it's WJCC versus the administration, where again, we have someone coming in and saying, actually, this is a Venezuelan person saying, hello, I'd like a preliminary injunction to prevent being, taken away without due process. So I thought, let's go ahead and just read through it. Yes. Hello, Dre, Cooley. Hello, welcome. Yes, and happy Juneteenth to you as well. This is an Independence Day. Hello, Mary. That's always good to celebrate our Independence Days. Even if independence came for different people at different times, still worth celebrating that. So I'm going to be a little careful here. I am noticing that my content has been dinged a little bit. So if you do see any of my posts, make sure to like the post or leave a comment so I can kind of get caught back up in the algorithm again. I know a lot of people are struggling with that right now. So just wanted to remind everybody. Yes, Navy Vet, you did. Good question, Kristen. But not yet. We'll see how this goes. So let me put the case number out here. Again, what I'm reading today is the preliminary injunction order that was granted in part and denied in part. So we'll see that. I've not read through it. This is my first time as well. From Kentucky. Well, hello. Oh, thanks, Rachel. Oh, thank you. Yes. Well, and that's what I'm trying to do, right? We got to figure out what everyone's saying here. Because the administration's doing that, right? They're using the words to kind of tangle things up. So I thought, well, we don't need all that. So here's our order, and for a preliminary injunction. I'm just going to do a prelim injunct here. And there we go. And this was filed yesterday. All right, there we are. So I'll just kind of read through the beginning here, what the introduction is, and then kind of skim through it to hit the highlights to see what we've got going on in this one. So here's the case here, and this is about, thank you so much. This is about a Venezuelan man, and they were requesting a preliminary injunction, and the court granted most of the injunction. Oh, thank you so much. Yes, so thoughts on the SCOTUS rulings yesterday. I am working on what I thought would be most helpful for people. I know there were like five cases that came down yesterday, but a couple of those are procedural rules that I think are great not the decisions, but I think it's great to rule on procedural cases, but they're really not highlighted. The big case, of course, that came out was the here we've got Skirmetti, and this is the Tennessee case. So I am going through and annotating this, and then what I thought I would do is just do a live taking everybody through my annotations to kind of make it a little bit easier. We have concurring opinions in here, we have dissents in here, and then we have the main body of the majority opinion. So once I make it through annotating all of these things, then I will do a full live walking through this case. At this point, it's kind of like you got to pick your cases because there's just so many. The other case too that I am working on is the lawsuit that the American Bar Association has filed. And they have filed a lot of stuff. They've done an ethics filing against Bondi, and then they've done this one, which has to do with the law firms that have been targeted by the administration. So that's a big deal. So I'll be going into that as well. So we've got lots of things on the docket. So I'm going to kind of do a bit more than I have been just to make sure that we get through it. Yeah, few rulings, yes. Just a couple. Yes, the Bar Association case. Yes, I think both of them are pretty big. Pretty, momentous, if you will. So I will be going through those. See the one on the National Guard in California. So have they issued, oh my gosh, did the panel issue a decision? They were just arguing it, and I've been waiting for their decision to come out. Oh goodness. Hello, good afternoon, Frank. Hello, welcome. Hi, Laddie. Thanks for coming in, stopping by, hanging out for a little bit. A little bit of our lunch and learn going on today. Oh, thank you so much, Tay, as always. No decision yet. Okay, thanks, Willie B. Yes, I've got the Newsom case is really the hot potato right now. It's just hot, trying to get it sorted out. Again, state versus federal power and lots of that. But, yeah, we're kind of waiting. I didn't see it yet. Will be unsealed. I don't know when it's going to be unsealed. I do know that it's still continuing to go forward at a very slow pace. But the exigency of that case, because he's back in the country, the exigency piece of it has slowed down. The case itself has not. So they're trying to kind of work through it right now. But when those pieces will be unsealed, that would be very helpful. I'm keeping my eye on that one too. So this is a different person. Yes. So let me dive in, everyone, here. We have a person by the initials here of WJCC, and they're a petitioner, and this is in Pennsylvania. Just to remind everybody, this is the Alien Enemies Act executive order situation, and that was an executive order that said that, we can just take you and ship you out of the country to wherever we want without actually giving you any due process. So the Alien Enemies Act itself is still controversial, has not been officially ruled on that it's appropriate. So that's the big question. But anyone who is kind of in this Alien Enemies Act zone, so the area where they could potentially be kicked out and to somewhere else, the act itself is still going through the system to make that determination if it's legal or not. Are you charging us? Nope, it's free. It's free to hang out and listen. I do have a Ven of the Mo, if anyone would like to donate to my Post-it fund. But other than that, nope, it's all free. Come on in, everybody. Come on in and hang out. For sure. So let me dive in here. We're in Pennsylvania. Here's the case number here. If you're interested, WJCC versus the administration, and our opinions coming in here. So I will just read out the introduction, and then we'll kind of skip through the rest. Here's our petitioner, who's a Venezuelan man who is currently in immigration custody and represents that he's subject to the proclamation. I, again, am careful with my language. My posts, a lot of my stuff is being kind of, shadow banned or is outside of the algorithm right now. So I do want to be careful with my words. So we'll just say subject to President's proclamation invoking the Alien Enemies Act regarding the invasion of the United States by this group. here. Pursuant to the Alien Enemies Act of 1798, 50 U.S. Code Section 21, requests that this court enter a preliminary injunction in this matter. Specifically, WJCC requests an injunction barring 1, his removal under the proclamation and the AEA absent 21 days notice. And this notice element's been very controversial. How much notice is needed here? So that's something that everyone's kind of questioning. And an opportunity to be heard consistent with this court's opinion, meaning that is the due process elements, right? So we've got a citation. And number 2, his transfer from the Western District of Pennsylvania, except as pursuant to Title 8 of the United States Code. So this is what he's asking for his due process pieces now that he's under the Alien Enemies Act. It really is keeping me busy. And, I'm okay to be not as busy. I'm okay if they wanted to stop, violating the Constitution. I'd be all right with that. We would, take a different turn then. For the following reasons, the court grants in part and denies in part WJCC's motion for a preliminary injunction. Specifically, the court grants the motion insofar as the court orders the government to comply with the notice requirements. Now, a friendly reminder, preliminary injunction, that's something that the court can put into place if a certain number of factors are met. So there's a test, and if you pass the test, then the court can give you a preliminary injunction. So we have orders the government to comply with the notice requirements that the court articulated in ASR. Another case here relative to WJCC. However, the court denies the motion insofar as he seeks an injunction barring his transfer from Pennsylvania, except as provided by Title 8. So he had 2 things he wanted. First, he wanted to be able to have notice and opportunity, and the court said, right, we can do that. And the second one is a location request, and the court said no. No preliminary injunction for that. So your location situation is going to be whatever it's going to be. All right, there you go. Let's see. So let's dive in. Background. This case begins with the AEA, which is the Alien Enemies Act, which provides that whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President makes public proclamation of the event, all native citizens, denizens, or subjects of the hostile nation or government being of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. The President's authorized in any such event by his proclamation thereof or other public act to direct the conduct to be observed on the part of the United States towards the aliens who become so liable, the manner and degree of the restraint to which they shall be subject, and in what cases and upon what security being permitted to reside within the U.S., refuse or neglect to depart therefrom, and to establish any other regulations which are found necessary in the premises and for public safety. So this is the Alien Enemies Act language set out here. And if you're looking specifically, you can pull up the code sections here. Yeah, we would all appreciate it. True story. True story. Oh my goodness. On March 14th of 2025, the President signed his proclamation invoking the AEA in relevant part. That proclamation provides as follows. So again, this is just kind of a review here. So on February 20th, the Secretary of State of the United States designated this group as a foreign bad organization pursuant to 8 U.S. Code Section 1189. This bad group has thousands of members. The bad group is closely aligned with and has infiltrated another regime, including its military and law enforcement apparatus. The bad group grew significantly while a bad person served as governor of a bad place. I don't know if the place is better or not, everyone. I'm doing my best with my language here. Between 2012 and 2017. In 2017, a bad person was appointed as the vice president of Venezuela. Soon thereafter, the United States Department of the Treasury designated this person as a specially designated trafficker under the Foreign Bad People Designation Act. This person is currently a United States fugitive facing charges arising from his violations of United States sanctions triggered by his Department of the Treasury designation. It's interesting. All right, so there's our background. Now, with that, that gives you a little insight into the executive order. So I am going to skip through the rest of this language here. Next, as a result of the foregoing, the president found that this group is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. This piece right here, this idea that the administration thinks that this is an incursion, is how they're trying to use the AEA, because there are a few magic words, and if you don't use the magic words, you can't use the Alien Enemies Act, and incursion is one of the magic words here. Further, the president concluded that the group is taking such action against the territory of the United States, both directly and at the direction, clandestine or otherwise, of the regime in Venezuela. As a result, the president directed that all Venezuelan citizens 14 years of age or older who are members of the bad group are within the United States and not actually naturalized or lawful permanent residents of the United States are liable to be apprehended, restrained, secured, and removed as alien enemies. So that sets out your parameters for the removal situation. And now we can dive into this particular case. That's a good question, Shelley, and it's possible. Although technically, again, we would need to have a situation where, war was actually declared, and that goes through Congress. So we would need that, and we seem to be hesitant to actually declare that. I mean, we didn't in Desert Storm in that situation. We haven't really declared it for a very long time, so we'd have to wait and see. On May 13th, the court entered its opinion in ASR. In that decision, the court found after extensive consideration and analysis, the proclamation meets the definition of predatory incursion under the AEA. That's still being argued. Further, the court analyzed the constitutionality of the notice that respondents wished to provide to individuals they deemed subject to the AEA and the proclamation. Specifically, respondents intended to provide individuals designated for removal under the AEA at least 12 hours notice in order to indicate they will seek habeas relief. If an individual indicates that he or she intends to file a habeas, then the respondents will give that individual at least another 24 hours to file. In the event that an individual filed habeas, respondents had no intent to remove that individual pending his or her litigation. Deeming that notice constitutionally deficient, the court held, and then this was the prior holding. Yeah, true, Rebecca, true. I agree. I'm being claimed as just the presence. Well, yeah, it seems that way. I agree. Quite deplorable. I agree. So the court's holding was respondents must provide to individual detainees who are subject to the AEA and the proclamation the following notice before removing them pursuant to those provisions of law. So we have our test here in order to see what needs to happen if you're going to use the AEA. 21 days notice and an opportunity to be heard. Notice, number 2, notice that clearly articulates the fact that the individual detainee is subject to removal under the proclamation and the AEA. And 3, notice in English and Spanish the language of those sought to be expelled, and if needed, Spanish to English interpreters shall be provided for necessary hearings. In the case of ASR, the respondents designate him as subject to the AEA and the proclamation. They must provide all of the foregoing notice to his counsel at that time. So this was a previous holding by the court of what was needed for notice and opportunity. Oh, thank you so much. Thank you so much. Yeah, I'm still trying to do my rainbows as much as possible this month. We need extra rainbows this month, everyone. Finally, the court rejected ASR's additional arguments challenging the legality of the proclamation. On May 21st, WJCC, which is this case, filed his habeas petition in this manner. In that document, he represented he's a Venezuelan man in immigration custody at risk of imminent removal under the proclamation invoking the AEA. On that same day, WJCC submitted an emergency motion for a temporary restraining order. Oh, thank you so much, everyone. Requesting an order barring 1, any removal outside the country pursuant to the AEA, and 2, any transfer outside of the Pennsylvania, outside of the district of Oh, thank you so much. That's so sweet. I love the stars. Oh my gosh. Britta B. Oh, that's so sweet. I appreciate you. Number 3, notice to petitioner and undersigned counsel of any designation of an alien enemy under the proclamation at least 21 days prior to any removal of the proclamation. Under the proclamation. So on May 22nd, the court entered a temporary restraining order in accordance with WJCC's request. This court separately set a briefing schedule on his motion and scheduled a hearing on that motion. All right, so we're going through the steps of due process. After receiving that briefing and conducting a hearing, this court entered an opinion and order on June 4th, extending the TRO until June 19th, which would be today. In its opinion, the court, 1, found that WJCC has standing to challenge his removal under the AEA and the proclamation. 2, held that it was appropriate to extend the TRO for 14 days. 3, ruled that it was appropriate to order respondents to provide WJCC with the same notice that the court articulated in ASR. 4, ordered respondents not to remove WJCC from Pennsylvania under any provision of law other than the Immigration and Nationality Act. And 5, denied WJCC's request for TRO in all other respects. And then we've got our order here. In its order, the court, 1, permitted WJCC to file a motion for a preliminary injunction and set a briefing schedule in the event he so filed. 2, scheduled a hearing on WJCC's motion for a preliminary injunction in the event that he so filed, and 3, directed that the court's TRO would expire upon the earlier of its resolution of any motion for preliminary injunction on June 19th at 9:32 a.m. That's specific. 9:32. 4, permitted WJCC to file an amended petition for a writ of habeas corpus. And 5, ordered that WJCC nominal bond of $1 remained appropriate for the entry of the TRO. On June 9th, WJCC filed a motion for a preliminary injunction. As the court noted earlier in that document, he seeks an injunction on those 2 pieces, and I won't reread through that language since I think I've read that maybe 5 times. Here we go. So 1 and 2. On that same day, WJCC filed a brief in support of his motion for a preliminary injunction. On the 12th, respondents filed their brief in opposition of WJCC's motion. Finally, on June 17th, WJCC filed his reply. All right. 2 particular aspects of respondents' brief in opposition are especially relevant to the resolution of WJCC's motion for a preliminary injunction. First, the respondents are the government. Respondents argue that WJCC lacks standing to pursue his claims regarding the AEA and the proclamation. Second, respondents provide this court with revised notice of procedures for individuals subject to removal under the AEA and the proclamation that they contend comply with law. These notice procedures are as follows. So the original notice that everyone's been talking about for the AEA, they came in and said, well, we've got new guidelines now. The new notice form tells aliens in a language they can understand. Now, one thing here, I'm going to just point out where our language gets blurry here. In a language they can understand according to who, right? Who's making that decision? That they can contest their removal under the AEA by filing a habeas petition in the district where they are detained. So what would happen then if they put them in a van and move them to another jurisdiction? Do they still have the ability to file habeas? They just move them across the state line. The notice form further informs aliens that they may retain counsel, right? But doesn't say that there's any way for them to actually retain counsel. Make calls for that purpose, all right? So they are allowed for that purpose, but if they say anything other than that purpose, would they have the phone removed? And will be given a list of potential counsel upon request. So not just out of the chute, but only if they ask. And again, this is implying that the people working with them can speak the same language and communicate. So I want to make sure that when I'm going through language like this, now that I clarify where those big questions would come from, since the administration's doing it, I think it's time we do it also. Aliens will be given 7 days from the receipt of that notice. So it's receipt of it, not when it's actually been typed or printed It has to be when they have received it. So what if they are receiving it in the middle of the night and they're asleep, right? So we've lost 8 hours of that notice to file habeas petition, during which time the aliens will not be removed under the AEA. Aliens who petition for habeas will not be removed until the petition is resolved. So again, 7 days. We don't know exactly how many hours that's going to be or when they give them that. And then here they're saying you'll not be removed under the AEA, but you could be removed under something else, right? You could be removed under the other parts. But aliens who petition for habeas will not be removed until that petition is resolved, until the habeas petition's resolved. We haven't talked about what removal could be under the INA, all right? So you can see now how the language gets tricky. And this, again, is exactly what the administration is doing with languages from the court order, court orders, motions, and various things. What they're doing is tangling up the language in a way that is, they're kind of being jerks about it. So I think, again, it's important to kind of go through and see where they may have those loopholes. Because the judge might say, sure, that notice is fine. And then they come back and use all of these blurred out pieces in order to harm. So on June 18th, this court held a hearing for WJCC's motion for a preliminary injunction. Finally, the court notes that on June 11th, WJCC filed an amended petition for writ of habeas corpus. In that document, he reiterates his contention that the notice respondents intend to provide to detainees subject to the AEA and the proclamation violates the Western District of Pennsylvania, and 3, notice, wrong page, we flipped it back. We'll just put this, okay, and violates, let's make sure we have the right one here. All right, so, and the proclamation violates the Fifth Amendment's due process clause. All right, further, WJCC contends that his continued detention without any evaluation of whether he poses a danger or flight risk violates the due process clause. So he's also saying it's not enough just to have a notice here, but why am I even here if I haven't had any information regarding me having this being a part of this group? So he's trying to say here that even the reason for detention is in question, so why am I still being detained? So he's going all the way back. And that's not one we've dealt with yet. We've said if you are detained, you have a right to habeas corpus, right? But what about why they detained you in the first place? Where's the evidence giving that? And that's a good question, because we have probable cause if we're in criminal court, but because we're in an administrative civil situation for detention, the rules are going to be a little bit different. So that's what he's asking about here. In the beginning of its discussions, WJCC's motion for a preliminary injunction, the court first incorporates by reference all of its legal conclusions from ASR, a prior case, regarding the legality of the proclamation and its implementation, and readopts them here in full. Further, having considered respondents' arguments, the court reaffirms its earlier conclusion that WJCC has standing to challenge his removal under the AEA and the proclamation. With those findings in place, the court's left to consider 2 primary issues in resolving WJCC's motion for a preliminary injunction. 1, whether the court should permit respondents to provide individuals subject to the AEA and the proclamation with the revised notice procedures alone, or continue to require respondents to provide WJCC with the notice that this court articulated in ASR. So here's the question then, right? Are they going to make it so they're requiring the respondents to have notice here, or are we going to go down the new road with the revised notice procedures, right? And number 2, whether to bar respondents from moving WJCC and from Pennsylvania under the AEA. For the following reasons, the court will continue to require respondents to comply with the notice it articulated in ASR. All right, so this means the original notice requirements set out in this case need to be followed. This newfangled notice requirement is not what they want unless it fits within the original notice requirements in ASR. All right. Relative to WJCC, and will not bar respondents from moving him from Pennsylvania under the Act. So number one, you need to follow the original notice rules that the court set out, not your own. And number two, if you want to get out of Pennsylvania, that's too bad. All right. I'm going to shake it down. I'm going to shake it down here, everyone. So here we go. Letter A, the court will continue to require respondents to comply with the notice that the court articulated in ASR relative to WJCC. So let's go through this piece. Moving people from place to place is, I'm going to assume, and we'll see in a minute, usually is because they have the control over what detention center works best. And that just has to do with being part of the enforcement squad, I guess. But this idea that they had brought their own notice, they're trying to bring their own notice into play, right? And we've seen here how it can be pretty blurry. And the court is saying, no, you need to use the court's notice. So here we go. Turning first to the issue of notice, the court begins with what WJCC must show in order to obtain a preliminary injunction. As the Third Circuit has explained, preliminary injunctive relief is an extraordinary remedy which should be granted only in limited circumstances. Here, citing this case, under the familiar standard of proof, a party seeking a preliminary injunction must establish that he, sticky note, that he is likely to succeed on the merits, he's likely to suffer irreparable harm in the absence of a preliminary injunction, that the balance of equities tips in his favor, and that an injunction is in the public interest. And this is the Winters test. We've talked about that quite a bit, so I'm going to skip down here. In light of this standard, the court now asks whether WJCC has shown a likelihood of success on the merits on the issue of notice. For the following reasons, the court finds that he has. So he has met the Winters element, right? So he passed the test as to the notice piece of it, all right? So that's the question. He's saying if you don't give me a preliminary injunction, then I'm going to suffer irreparable harm. It's going to not be in public interest if we go down that road. So the court is saying here, you've met the burden that you need in order for a preliminary injunction, all right? Here we go. 3 days after this court issued the decision in ASR, the United States Supreme Court issued its ruling in AARP. Therein, the Supreme Court stressed that it was not addressing the underlying merits of the parties' claims regarding the legality of the removals under the AEA. However, the Supreme Court did offer the following articulation of what process the Fifth Amendment requires in this context. So we'll take a few minutes. Oh, we love the rainbows. We love the rainbows. There can be no shortage of rainbows this month, everyone. It should be every month, but we're loving that. We're loving that here. All right, let's read through the Supreme Court because I think it gives us a great little outline again, a little refresher. Oh, yay, we love it. We love it. All right, the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. Procedural due process rules are meant to protect against the mistaken or unjustified deprivation of life, liberty, or property. Here, we have long held that no person shall be removed from the United States without opportunity at some time to be heard. Here, and due process requires notice that is reasonably calculated under all circumstances to apprise interested parties, and that affords a reasonable time to make an appearance. Accordingly, in JGG, the court explained, with all 9 justices agreeing that the AEA detainees must receive notice that they are subject to removal under the AEA within a reasonable time and in such a manner as will allow them to actually seek habeas relief before removal. In order to actually seek habeas relief, a detainee must have sufficient time and information to reasonably be able to contact counsel, file a petition, and pursue appropriate relief. This is from SCOTUS, all right? This isn't this court being like, let's do this and that and the other. No, this is SCOTUS wrote that. That's important. Therefore, here we go. After that, therefore, after taking stock of the certain circumstances relative to the removals under the AEA and the proclamation, the court held that notice roughly 24 hours before removal, devoid of information about how to exercise due process rights to contest the removal, surely did not pass muster. All right, so they're saying this isn't enough. This isn't enough to meet due process. Identifying the following circumstances and reaching that conclusion. 1, the nature of the notice that the government was providing to AEA detainees. 2, the uncontested assertion that the government was poised to carry out removals imminently. And 3, the fact that the government had represented elsewhere that it is unable to provide for the return of an individual deported in error to El Salvador. At the onset, the court observes that the foregoing law strongly supports its decision to persist in requiring the notice that it articulated. Again, the court is saying you need to use our standards, not your own. You need to use what the court has set out for guidance. In opposition to this finding, respondents stress that the revised notice procedures that they wish to apply afford far greater process than what the federal immigration laws offer in analogous contexts. Specifically, respondents point to the expedited removal process under 8 U.S. Code Section 1225B, which subjects certain illegal aliens to immediate removal without further notice or review. Subject to only the limited window to establish a credible fear of prosecution. However, for 2 primary reasons, the court finds that the expedited removal process under Section 1225B is not an appropriate analog here. So when we're dealing with this kind of an issue, the AEA issue, you've been detained and the removal is imminent, what they have used before is not close enough to the current situation to use again. First, the expedited removal procedures applied to aliens who have not been physically present in the United States continuously for the 2-year period immediately prior to the date of the determination of inadmissibility, among other things. Conversely, the proclamation applies to 1, Venezuelan citizens, 2, who are 14 years of age or older, and 3, who are within the United States, 4, who are neither actually naturalized nor lawful permanent residents, and 5, who are members of this bed group. The court's point in noting this distinction is simply to highlight the fact that the expedited removal procedures and the AEA, the proclamation, clearly apply to different categories of aliens, albeit with the potential for overlap between the two. That's kind of a big deal. Second, and more to the point, under the expedited removal procedures, an alien subject to the removal has statutory opportunity to indicate an intention to apply for asylum or fear of prosecution. Tea break. And we're still under this expedited situation, which is 1225 here. If an alien so indicates, the alien receives an interview by an asylum officer, which is what's supposed to be going on for the group that didn't make it all the way to South Sudan. I've not checked to see if that information's come back in. I need to do that today. And if that officer determines that the alien does not have a credible fear of prosecution, that alien may seek prompt review by an immigration judge. Evidently, in the expedited removal context, an alien can seek a hearing on certain issues within the branch of government by which he is detained. Conversely, in the context of an individual detained under the AEA and the proclamation, the government's proffered notice would apparently only permit a detainee to go to another branch of government and seek a hearing from the judiciary. In other words, in the expedited removal context, a detainee's capacity for hearing is much narrower at hand than it would be under the AEA proclamation context. The court finds the fact highly significant in weighing what the Constitution requires in the context of the AEA in the proclamation. So he's saying here, the rules they're using for expedited removal, all right, so let's break this down here. The expedited removal section, the hearing and the notice that are set there are not going to cover this particular act. So we're talking about the AEA. Hold on here, everybody. So the AEA's code section that is being used is 50 U.S. Code here, section 21. So what the judge is saying is the requirements for the hearing and such for this section of the code is different than what's needed for this section. And this section needs more. And for that reason, then, the new rules that they're trying to implement, that the government's trying to use, the new one that they just set out is not enough to cover the Constitution. All right? So again, here's the new set that they want to do here. The procedures have changed to this, and the court is saying if you're using the AEA, no, you may not use that because that does not fit within the context of the Constitution. They're still there? Oh my gosh. Only given contact information on the 11th. Oh my goodness gracious. Well, I'll have to take a peek at that. Yikes. All right. So again, this was a very important point for the court here. The court offers the following hypothetical to illustrate its point. Assume that detainee John Doe, who is housed in Moshannon Valley Processing Center in the Pennsylvania, receives notice on June 1st at 12 p.m. that he's subject to removal under the AEA and the proclamation. His only recourse is to file with the judiciary in habeas. Thus, unlike an individual in expedited removal proceedings, he apparently may not tell an immigration officer or his intention. Immigration officer of, that's an F, not an R, of his intention to apply for asylum or his fear of persecution and thereby obtain a hearing. So this is the expedited hearing piece here, all right? Assume that John Doe then begins drafting through whatever means are available to him a habeas petition to file in federal court in Pennsylvania and or places a call to his or her attorney if he has one. Halfway through drafting his petition or while waiting for a callback from his attorney or while still looking for one, on June 4th at 5 p.m. he's placed on a plane which will arrive in the Northern District of Texas at 7:45 p.m. That same evening. He has no opportunity to take his partially drafted petition with him or call his attorney or find an attorney before he's transferred. After arriving at the Blue Bonnet Detention Center here, on June 4th, he takes most of the day on June 5th to acclimate himself to his surroundings, look for means within the facility to redraft his habeas petition, and places another call to his attorney. So this is exactly what I was talking about, everyone, when I was going through the words and explaining, where the holes were, where the problems were with the new notice. Let me grab this again here. So we were talking about the different pieces that could be very troublesome. And the piece that they're talking about is filing a habeas petition in the district where they are detained. So they're saying, look, if you move him around, he's going to have to go forward and file a new habeas situation. All right, so by the time he finds the means for drafting a petition or hears back from his attorney, it's June 6th, and he stands to be removed from the country in just 2 days. Might there not be a significant risk that this individual will not reach the judiciary before his 7 days have run their course, meaning that he would be removed without any hearing whatsoever? Might not his movements from one facility to another, his quest to draft a petition, and or his search for words from an attorney take even longer than the timeframes that the court has just prescribed? Now we've got a question here. We're in a hypothetical situation here with this judge. The court cannot help but answer those questions in the affirmative. Therefore, having considered the Supreme Court's longstanding holding that no person shall be removed from the United States without opportunity at some time to be heard, and after again weighing the realities of ICE removal proceedings, the risk of errant removals, and the burden upon the government, the court reaffirms its finding that the Due Process Clause mandates that notice requirements that this court articulated in ASR, regardless of the contours of the distinguishable expedited removal proceedings. Accordingly, the court finds WJCC has shown a likelihood of success on the merits insofar as he seeks the following notice before his removal from this country under the AEA and proclamation. 1, 21 days, notice and an opportunity to be heard. 2, notice that clearly articulates the fact that he's subject to removal under the proclamation and the AEA. 3, notice in English and Spanish the language of one sought to be expelled, and if needed, Spanish to English interpreters shall be provided for any necessary hearings. And 4, notice of all of the foregoing to his counsel. This is the notice that the court set out. All right. This is what they're saying is appropriate notice. Meanwhile, the government said, well, we're going to do this now. This is what we want to do. This is their new procedure. And the court is saying mine's better. Turning to irreparable harm, the Supreme Court has explained that the Illegal Immigration Reform and Immigration Responsibility Act of '96 allows for continued prosecution of a petition after removal. Accordingly, the burden of removal alone cannot constitute the requisite irreparable injury in that context, because aliens who are removed may continue to pursue their petitions for review, and those who prevail can be afforded effective relief by facilitation of their return, along with restoration of the immigration status that they had upon removal. Conversely, in the context of the AEA, the law is far from settled. And as the United States District Court of the Southern District of New York recently noted, current events make it unclear whether individuals who are removed from the country but are not actually subject to removal, that is, individuals who are removed in error, will be able to return. So this is a new area of the law that we're looking at. All right. So this is a brand new piece of what has to be considered. That the fact that there's no ability to rely on the government to not wrongfully take someone out of the country. That point is now on the books. Before it was, the government will do the best they can. If mistakes get made, we're all people. But because of what happened with Garcia, the courts recognize that the government, if they make a mistake, are going to be fine with that, and that it is going to be a legal battle to get that error fixed. So this would be a landmark moment, all right, where our laws have turned a little bit because of what has happened in the Garcia case. Here, noting that the government had represented elsewhere that it's unable to provide for the return of an individual deported in error to a prison in El Salvador. So this is on the books now. So the judges, and that means the judges are going to be more strict. They're going to say, hey, look, if I get this wrong, y'all are going to just ship someone to, a prison in another country. So the judges now have to put up extra protections to ensure that the government does not have the capability of prison in another country. So the judges now have to put up extra protections to ensure that the government does not have the capability of just pulling someone out and sending them to another country. That is the legacy here. That's what's going on. So further, respondents have apparently still declined to enter into a binding stipulation with WJCC, providing that they will afford him the notice that this court articulated in ASR in the absence of an order from this court in this case, and the fact that respondents now seek to remove individuals under the AEA and the proclamation on 7 days' notice confirms the necessity of this court's actions in this context. So they want 7 days. The court said it needs to be 21. And then the court in this case is coming back and saying it needs to be 21 days. Yeah, it is. But we've definitely, we're going down a little different road than we were before. This is going to be kind of our new normal. Therefore, for all of the foregoing reasons, WJCC has shown that, in the absence of a preliminary injunction from this court, he faces a significant risk of removal to another country under the AEA and the proclamation without sufficient notice and opportunity to be heard before such removal, and without the possibility of return to this country. Again, this is what happened because the government screwed the Garcia case up so much. This would not even be a piece to consider before that happened. But now the judges are putting checks into place on the government because of that. In the event such removal is eventually found to be unlawful. Therefore, the court finds that WJCC has shown a significant likelihood of irreparable harm. Right? So we're adding on to that. Another piece of the harm that can be argued in every single case can be, well, they might wrongfully take me to another country. Sufficient to warrant a preliminary injunction. Yeah, so the preliminary injunction piece of it has additional elements as proof. Finally, with respect to the balance of equities and the public interest, because WJCC is currently detained, he's not posing a risk to public safety at this time. And if this court does not grant WJCC injunctive relief, there's a significant risk he'll be deprived of his rights due him under the Supreme Court precedent. Therefore, the court finds that the two remaining factors support the grant of a TRO on the issue of notice in this case. So the court is saying, yeah, you need a TRO. And because of what happened in Garcia, I think you are at risk. So you definitely have some elements here that are in risk. Accordingly, the court grants WJCC's motion for preliminary injunction insofar as it seeks an order requiring respondents to provide him with the same notice the court articulated in ASR. Pardon me here. And then we're into Section B. Now, I'm going to skip through this because where the location is of where they are, that's something that we can kind of hammer out later. And then we'll go forward again. They're just saying why the request to be kept in Pennsylvania isn't needed for the preliminary injunction. And I think probably another big part of that is because you've got 21 days. So you've got more time under the court's notice rules. Conclusion: for all the foregoing reasons, court grants in part. So the court notice requirements, the government has to follow those, and denies in part, meaning location. So location cannot be set in specifics for this case. WJCC's motion for a preliminary injunction. Here, an appropriate order will follow. And this is, again, out of Pennsylvania. Let me make sure I have the cover sheet here. So we're in the Western District of Pennsylvania. All right, so did everybody follow me here on this case? Again, this order just came out yesterday, and it has to do with two particular pieces on the preliminary injunction. One was granted, one was not granted. All right, we'll do a frowny face there, okay? Okay, just got here. Yes, okay. Yeah. Oh, my goodness gracious. All right, so the bottom line is we're continuing on with the Alien Enemies Act being a way for them to go through detaining people and deporting people, and that's okay. But if you're in Pennsylvania, you need to follow the court's rules on notice. We're not going to be able to cut a notice down to 7 days. That's not going to be appropriate. So although there is a section of the code that allows for expedited cases, so they can, expedite the removal proceedings, that is not going to come into play under AEA cases. So you can't just use the expedited removal proceedings as justification for bumping 21 days notice down to 7, because it's not going to work out here. Right, so he's asking here in the original ask, he's saying he wants his transfer from the Western District of Pennsylvania, except as pursuant to Title 8 of the United States Code. So he's like, if you are going to transfer me out of where I'm at, you can only do that under Title 8. You cannot use the Alien Enemies Act and how you've picked me up and put me in here as a means to be moved around. You have to have a higher standard. And the court's saying, no, you don't. They can remove depending on what they need at the time. Yep. Oh, sure. Makes sense more now since they were early. I know, right? When we put it all together, it's a little bit easier as we go through it. And again, the Garcia case is still ongoing. The JGG case now, which is now referred to as the Sanchez case, is still going. We've got, and the AARP case, which is initials, not the group, that is still going as well. All of these cases are still going. We don't have definitive answers yet on this. Oh, of course, Hannah. I'm happy to kind of come in and try to explain. This is kind of weird how this whole thing is, because we're basically charting the path right now. And that's kind of what's going on in a lot of different things with all of these cases, is we're charting the path. So we're clearing the path for what will happen in the future. So if this ever comes to light again, or there becomes another question, because honestly, if this Alien Enemies Act does not get knocked down, what's going to happen is that any president is going to come in and do an executive order declaring an invasion of something, right? It could be, sea turtles, right? The invasion of sea turtles. And so now that opens up the Alien Enemies Act. And now anyone from, the Sea Turtle Island now can just be kicked out, right? So that's what's happening here. So we got to be careful, because once this door's open, if there aren't any parameters, then it's going to just keep happening over and over and over again. And that will be the legacy of the Alien Enemies Act. And I'm not sure that's really the purpose, right? I mean, they were clear about what's a war, but now for redefining what an incursion is, I mean, it could be anything. Yeah, it could be, right, it could be anything, because that's what's happened here. Typically what happens is there needs to be a war or incursion declared, right? So, of course, back in the Declaration of War Times, World War II, obviously, and then after 9/11, they attempted to put in an incursion and were denied. And then now here we are again with this information where it's like, well, I think there's an incursion. Sure, let's go with that. Turtle Island. Yes, thank you very much. Kick out the sea turtle. Well, that's what I'm saying, right? If you don't have any rules and you have someone with a goal, right? What's the end goal here? And as we all know, in this administration, the end goal is to have only the people that they want in the country. And so that's the end goal. So they're going to figure out, well, what can I do? Well, I can declare that there's an incursion. I can put it through the courts. That'll take years. In the interim, we're just kicking people out left and right because, they're, and as the judge even said in this case, well, even if they're wrongly kicked out, then the U.S. has said they're not going to do anything to bring them back. So that would be huge. So that's really the road that we're walking down now, the road where the president of the United States can come in and say there's an incursion in his mind, there's an incursion, and then invoke the Alien Enemies Act. And it could be anything, it really could be. It could be like, the monarchs came up from the south, or like, death hornets, whatever. It doesn't matter. It could be like Grenada. I mean, it could be any group of people at all. I mean, and quite frankly, this again is unlocking this whole new way of the government going forward when they're trying to get rid of people. Like a group of people, well, you're bothering me, so I'm going to just get rid of you by declaring an incursion. So, right. And the court has not clarified that yet, although this court is saying, well, we thought that it was an incursion, blah, blah, blah. But again, that's not been decided by the Supreme Court. We have to wait. Exactly, VC. Yep. New code word, sea turtles. All right. Oh, yeah, Wizard of Oz vibes. Exactly. Right. Well, in the authority here of the president, the authority for commander-in-chief, yes. As the president, yes. But at the time when those powers were put into place and the way that they looked at it, they were looking at George Washington. George Washington was standing in front of them in full military regalia. And he's like, don't worry about it, fellas. I'll keep an eye on the country. Right? So they're like, okay, commander-in-chief, blah, 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 blah. But then now we've got people that have no idea how the military works or any kind of experience in the military whatsoever, which, maybe don't need to. But then they don't have any idea how it works. And they're just like, yeah, sure, I'm going to be the commander-in-chief. It's almost like an afterthought. And so now troops and our soldiers are being pushed and pulled into different places on the whims of someone who has no understanding truly of how it works. And unfortunately, too, with this particular person, not only is there a lack of understanding, but there's this kind of vindictiveness against any military people that disagreed with him in the past. So now we have a whole nother issue where we're trying to say, for the people that know what's going on, like, you need to protect yourself. It's shocking to watch. I think that's a great way of saying it. Yeah, it's a great way of saying it. It is shocking to watch, and we're all just kind of getting thrown around here as they go through these different hoops that they are creating, and again, it's like they're using the words differently, which is a jerk move. But then it's like they think nobody else can use those words. Like this judge did the same thing I did with that new notice, where they're saying, no, I mean, if you do it this way, then you're going to make it impossible for the due process to click in. And which is what I was talking about as well. Like, this is too vague, this is too long, this is too short, you're moving too quickly, all of those things. So you just have to be, we have to just be acknowledge that now. When we look at the motions, when we look at what's happening, we have to make sure that we put on our, jerk attorney hat and go through and make sure that we see where they're going to try to blur the lines because they're jerks. Because that's how they're doing that these days, apparently. Here we go. Can he say there's an incursion of socialists and then kick out the registered Democrats? Wow, that's a great question. That's a great question. The Alien Enemy Act, though, the language only applies to non-citizens. So I think if you're a Democrat and you're a citizen, you're not going to be kicked out under the Alien Enemies Act. But really, like, nobody should be. Nobody should. But I wouldn't put it past them to try, right? And that's what they're doing. They're just kind of testing all these different things. Like, hey, let's fire everybody and see what happens. Or, hey, let's not give the money where the money's supposed to go and just see what happens. And, like, fine, screw up for 4 years, but the next president that comes in, they're going to be able to do that too. And then the president after that, and the president after that. So it's not just for Mr. Orange being able to take over the country. That's not what it's about. It's like fundamentally changing how the country works if they don't get it cleaned up. And that could be a problem. Will it increase to potence? No, I don't think so. We have other statutes that click into place if war is actually declared. Martial law is a different animal. Right now, we're still kind of trying to figure out how exactly that's going to work through the system, but I don't think so. Well, I don't know. I mean, it depends on, again, how they want to bring out those executive orders and kind of jerk things around. How long until they try to take citizenship away from charges? That's a good question. I don't know. That's a great question. I mean, treason's kind of a big deal, but it's also one that we don't want to mess with right now because, we're dealing with so many other things. I would say after the midterm elections, we could revisit that. We could revisit how that goes. Does not seem to be an issue until they get called out, then release the one being... Well, right. I mean, it's such a mess. Oh my gosh. I tell you what, I was just reading the case yesterday, the funding, specifically the AIDS funding case. And I tell you what, it's just absolutely heartbreaking. Heartbreaking, people, heartbreaking. I don't have to tell all of you, So the best thing that we can do, because a lot of people are like, oh my gosh, what can we do? Well, you need to educate yourselves. And that's what I'm doing too. You just educate yourselves on what the actual rules are, what you can do to protect yourself and your family under the rules. There's whole new areas of law and of rules that I never looked at before, like the AEA statute on international emergencies for the tariffs. Like, I had no idea how that worked, or how the International Trade Court works. So this is the time where you really need to firm up how things actually work, how the government works, how things are supposed to be held accountable, how the checks work, and what's a check and what's not a check, and how far the power goes. So I think that's one of the most important things, is that knowledge. So this is like knowledge gathering time as everything's on fire. Where can we find the case regarding the aid funding? Let me see here. Oh, I'm trying to find hold on here. Well, I think I'll have to, oh, one more stack, just a second here. One more stack. It might be in this one. Is it going to be in the, is it going to be in this one? No, that's the professor case. Let's see. State of California. No, that's not it. Oh. Yeah, I'm not, I don't have it at my fingertips. I apologize, but I can do a little post on it if people are interested. Just a little post that gives you the number. So this case actually has an incredible history. The docket is a huge mess because it's there are problems because people are not complying. So all right, so let me make a little post on it. It's again one of our closet dockets cases. Let me see. No, that's Florida immigration. Yeah, I just don't know where to put it. I tell you, I'm swimming in paperwork here, everybody. But I'll do an update on that case for you today. I'll have it, I'll film it and then just have it posted today. So keep your eyes out for it, everyone. Definitely interested. Okay, excellent, excellent. Have we been to war and still had elections? I'm wondering if he thinks, yes, we still had elections. We've still had elections, throughout the entire process. And it's kind of been weird too. Like the elections aren't perfect, but they are still going. There's some things that have definitely been put on pause though, but I don't think in this situation would be. Doe's 126B Musk. Yeah, that could be. That could be VC. That could be. I mean, it's about the dismantling and reduction of funds that was pulled. It could be. We've got several Doe cases going, so I'm not exactly sure, but could be. Yeah, could be. I was looking at those Doge cases just the other day as well. I am prepared today. My content schedule is to go through the closet docket. So I'll be making a lot of posts. So don't get too sick of the sticky notes, everybody, but that's like today's content plan is to do that. So yes, US aid. Yeah, I'll be definitely putting the closet docket up. I'll make sure right after I leave here that I put it together so everyone's got the link or everyone's got the number. The other thing too, I'm going through and annotating the Scarmetti case, right? So this is a Tennessee law that has been upheld by the court. I will be going through this once I finish annotating it. I'll do a live on that. And then I've also got the American Bar Association complaint that I will do another, once I annotate it out, I'll be doing another live on that. So that's kind of where I'm at with my content. So we've got closet docket and then two major cases that I'm going to try to put together here over the next little bit. And then of course we have whatever other cases come down that are crazy town. Yes, I have, Crispy. I've looked into the Rockland, New York case, but what I'll do is I need to make a note. I'm not sure, VC or Kea, is it up on my YouTube yet or not? I'm not sure if I've posted that one or not. They're kind of getting all tangled up because I've been doing so many, I have a hard time. But what I'll do is make sure that it's up today. Oh my gosh, of course, Willie B. Our moderators are amazing. I'm so thankful. Yes, and right. I've done a full live on it. I've gone through all the paperwork. I've gone through the exhibits. I've gone through what they're doing. So all of the details are there. It's just I'm not sure if it's been up or not. Right. So I'll take a look at that for sure. So I've got the AIDS case I'll do an update on. And actually, I think there are a couple. I think there might be 2 AIDS cases. And then the closet docket, and then I'll also make sure that we have this up. Emergency stay, well, we'll see. Yikes, it's a mess. Yeah, it's a mess. Anything on vets being denied health care and benefits or being single or nothing in the legal system yet. Nothing that's been filed. Yeah, I mean, there's a lot going on, everybody. We're at about 270 cases now. I mean, I'm on my 5th board. And plus we've got all the executive orders. We've had a handful of new executive orders that have come down too. And then we've got, the Supreme Court coming in with all this stuff. It's like, I'm going to need you to calm down, Supreme Court. I'm gonna need you to calm down. But we'll get there. We'll get there at some point, hopefully. Oh, Ashley, no, I'm happy to help. This is such a scary time, I think, for a lot of people because we just don't know what the procedures are. Now, the other thing, too, that makes it scary is that we don't know if the person in front of us is going to follow the procedures, which is a whole nother, issue. It's a huge issue right now. So we've got a lot. We've got a lot on our plates here, for sure. But again, my advice to anyone is if you see anyone in uniform and it's not like a relative, or even if it is a relative, quite frankly, just turn and go the other direction. All right. Walk away slowly. They're not your friends right now. Right. So take it easy on that and just make sure you understand your basic Fourth Amendment, Fifth Amendment rights here. Yep. Education, absolutely. Oh, thanks, Nancy. Oh, you're so sweet. I appreciate that. DM. I'll double check, Ashley, and see what I've got. Okay, yeah, let me take a look. We've never had an Indian in office before. I thought we had with George W. Bush, but I was wrong. Like, I'll admit when I was wrong, and I was wrong with that. All right. All right, or a group of someone in mask. Excellent. Oh, no, you could be a U.S. citizen and still have that coming for you. But maybe you've missed all of those cases. Those are going to be some good lawsuits going on there. We got to give it a little time. So with that, my friends, I will go ahead and sign off for our fun lunch and learn today. This is, again, the update on WJCC, which is good because they're trying to use a different set of notice rules, and the court is saying, no, you need to use our rules. So that's pretty good with that. I will be back on. I'm not sure exactly when, but hopefully I will see you all soon. And I will be posting up updates on the closet docket after I finish up. So take care, everyone. Have a great one. Thanks for coming by. Oh, yeah. And go look for me over on the tube. I'm over there as well. Bye.